And without further ado, I would like to introduce Mr. Gov Hutchinson. He has been with the California Association of REALTORS since 1985, manages the Member Legal Services program in LA. I'm sure you guys are all familiar, your friend and mine, Mr. Gov Hutchinson.
All right, good morning. And I think I'm on Zoom too. Hello, everyone who's too lazy to get over here. No, I'm just kidding. It's just kidding. Just kidding. Actually, you guys got a good crowd. I mean, some places I go, it's like half on Zoom or a quarter on Zoom. So good to see you. Good to be in person. This is a time of year when I do a lot of this because what just happened is Saturday was the deadline for the governor to sign all the new laws. So I'm going to tell you about all the new laws. I know you want to talk about the buyer brokerage stuff. I will talk about that. And I'll talk about I'll talk about forms also. I think I have enough time, but I'll start with just talking about the new laws. How many laws do you think the governor signed last couple of weeks? Too many. That's a good answer. Over 1,000. How many of them relate to real estate? 900, no, just about, like 40 or 50. You all got Newsline last night from CAR, if you remember. One of the items on there, you can just click on it, and it has the written summary of what I'm talking about today. Maybe about 30 laws. I'm going to just talk about like 10 or so. But you all got the email last night, if you remember. Just look at Newsline, click on the item that says 2024 new laws. It has a written summary of everything I'm talking about today as far as the new laws are concerned. So let me get into that first, talk about them. As always, there are a few laws. I mean, you wouldn't like, most of them are not good for landlords, especially, but I'll start with the transactional ones, then I'll talk about the rental ones. And as I said, I'll talk about buyer brokerage and forms after that. If you have questions, just raise your hand. I'll wait till the end, just very informal here. First, let's talk about disclosure laws. It's always good to know new on disclosure laws. There are 3 you'd find interesting. One of them, I'll start with the good news, maybe the only good news I have today. Okay. Remind me, in this area, do you have a lot of fire zones? Not too many. Some areas I go, the entire place is very high or high fire hazard severity zones. And the basic rule is if you have a listing, your listing is in one of 4 categories. It's either in a very high fire zone, a high fire zone, a moderate fire zone, or no fire zone. If you're in the top 2, you need this fire hardening defensible space form. So the question of every listing you have is, how do I determine if my listing is in one of those 2 zones? And the answer has always been, look at your NHD report. And the NHD report on the cover sheet has 2 fire zones. One of them says very high fire zone. One of them says wildland area. If neither box is checked, you're good. No fire zone. If the very high box is checked, you're in a very high fire zone. You need the fire hardening defensible space form. But what if the wildland area box is checked? That doesn't tell you enough. That tells you you're either in a high or a moderate. But you need to investigate further to see which one it is. How do you investigate further? You can talk to your NHD rep. You can call the fire marshal, or you can go online yourself and try to look at the maps. Here's the good news. Starting January 1st, you're not going to have to talk to anybody, because on the form itself, the NHD form itself is changing. And there's going to be a simple yes or no box. Isn't that great? If it's checked yes, you're in a high or very high fire zone. If it's checked no, you're not. Now, it's going to give you the detail underneath. In other words, why the box is checked. It's because you're in a very high fire zone in a state responsibility area or something like that. You'll get the detail. But who cares about the detail? All you want to know is, do I need the fire hardening form? And it's just going to be a simple yes or no, a quick glance, and that'll start all transactions after January 1st. Remember, it's the responsibility of the NHD company. By paying them, they've taken on the responsibility to do this for you. So they're going to make sure this happens. Okay. This is the only good news I have for you today. That's the only real, that's a new law. That's a positive change for realtors, makes it easier to do your job in one small respect. All right. 2 more disclosure laws. One of them is kind of interesting. When you are selling a house, right? sellers lived in that house 20, 30 years. Are you required to tell the buyer about all the repairs and renovations the seller has done over the last 30 years? The answer is it's not really clear. There's a question on the seller property questionnaire. Seller, you have to disclose any major repairs you've done. What the heck is a major repair, right? I mean, that's always a gray area. And when in doubt, disclose, blah, blah, blah. But it's, major, not little things, major things. So that's one thing. Here's a new law coming. It's going to clarify that with respect to certain sellers, namely what we call flippers, someone who buys and resells it quickly. And this law defines a flipper, listen to this, as someone who is selling a house within 18 months of buying it. Okay, so in other words, they accept an offer within 18 months of closing escrow on this property. We're talking about residential, 1 to 4. The new law says, which takes effect in July, not till July, says in those transactions, the seller, who's only owned it for 18 months or less, must disclose in writing everything they did. Well, everything they did if they hired a contractor. If they didn't hire a contractor, everything they did over $500. So if you hired a contractor and it only costs $300, you still got to disclose it. If you didn't hire a contractor and it costs less than $500, you don't. But anyway, and how are you going to remember this? You're not going to have to remember this. There's going to be a new box on the transfer disclosure statement reminding of this. And then there's going to be a new question on the seller property questionnaire reminding you this. Hey, if seller, are you someone who's just bought this property, selling it within 18 months, then you have to fill out the following information. If you've acquired any permits in this process, those permits must be provided to the buyer. If you don't have the permits, you must give the contact information for the contractor, any contractor you used in those 18 months. Okay, so we have an enhanced disclosure responsibility for certain sellers who are selling property within 18 months of buying it. Okay. Regular sellers, we still don't really know. You have to disclose material repairs that you've done since you've owned the property. You can always call the hotline. We'll give you our opinion, whether it's material or just when in doubt, just disclose it. But now we have a clear definition, at least for some sellers. Okay. All right. Yes. Don't be sorry at all. Yeah. Right. Yeah. Right. No, I understand. Yeah,
okay,
he's saying,
so I'll say it again. So if you were a seller intending,
it doesn't matter
live
about
in
the
house,
intent.
but you,
In other words, you're not a real flipper. The reason you're selling is because something came up, you had to sell. Yeah, you're still under this. It's a pure definition of how long and nothing else. Remember, it starts July 1st, not until then. All right. The third and final disclosure is really not going to affect, you don't really care about this too much. The environmental hazards booklet. Do you know the environmental hazards booklet currently has 6 chapters? I'll give you $1 if you can tell me all. Okay, there's a chapter on formaldehyde, radon, asbestos, household hazardous waste, lead paint, and mold. Thank you. See, you know this. They're going to have 3 new chapters. Aren't you excited by this? The 3 new chapters are going to be, hold on to your hats, a chapter on wildfires, a chapter on climate change, and a chapter on sea level rise, which I'm sure you don't care too much about that here, which leads to another question. Is the environmental hazards booklet a required disclosure? Actually, no and yes. Here's the, in case you, who cares about this? But the point is, the law says when you give the environmental hazards booklet to your client, you have satisfied any obligation you have to disclose general information about those topics, which begs the question, if I don't use the environmental hazards booklet, what is my obligation to disclose asbestos or mold issues to my client? Nobody knows. The point is, if you give them the booklet, you've done it. Okay. So I guess if you look at it that way, it's pretty much mandatory if you have any sense at all, because you don't want anyone coming back and saying, you never told me about this thing called asbestos. I should have known about this thing called asbestos. So if you look at it that way, the booklet is required. When are these new chapters going to be added? Nobody knows. You don't care. You just keep providing the booklet. One day the booklet will be a little longer than it was before. Just keep doing it. No big deal at all. You probably would have never noticed this anyway. Nobody looks at this booklet anyway, but there's going to be a change. All right. Okay. Those are 3 disclosure laws, no more disclosure laws. Next topic, other laws that are not disclosure. Here's what I think might turn out to be maybe the most interesting new law of all. If you haven't noticed, the government of California wants you to build an accessory dwelling unit. They want you to do it. Remember that law that came out last year that I talked about, SB 9? Remember that law that was said, oh, everyone can, with a single family house, is going to be able to add another house on their property. And some people are going to be able to do a lot split. So every house was going to turn into a 4-plex. That's not happening. Nobody's doing it. It's too hard. There are too many obstacles that can go in your way. The HOA can stop you. The city can stop you if you're in any type of earthquake, fire, or flood zone. It's complicated. In the entire state of California, since that law passed, something like 250 people have used SB 9 to add another property. It's just not happening. But in the last year, something like 40,000 people have added ADUs to their property. And this is a big thing. And why are they doing that? Because it's easy. I mean, the city of Bakersfield, Kern County cannot stop you from doing it. Your HOA cannot stop you from doing it. As long as you get a building permit, right? As long as you're qualified to get a building permit, the government has no and the HOA has no discretion really. Mainly, I mean, there's a size limit and a height limit and a setback requirement. But if you meet those, no one can pretty much stop you from building an ADU. And there's another law that says nobody can stop you from renting it out. I mean, some cities try to have laws that say, well, if you have an ADU, you know, you can't rent it out or something like that, or you have to live in at least the main house. No, none of that's true either. Well, here's the newest thing. This is kind of shocking when you think about it for a second. There's a new law that the governor signed, takes effect January 1st, that says local governments have the power to pass a local ordinance enabling people who have a single family home and an ADU on their property to sell them separately. In other words, what it would do is your ADU would be like a condo. So you'd be selling it. In other words, you could still own the lot, still own the house, still own the land, but you're selling to anybody who wants to buy it as a condo, the ADU. Now, for this to happen, this may not happen because, first of all, the city has to do it. Second, any lien holder on the property would have to approve it. So if you have a loan against the property, the lender, for whatever reason, could say no. Plus, homeowner association could say no also. But assuming the city does it, assuming it's fully paid off, or the lien holders don't care, assuming there's no HOA or the HOA doesn't care, this could be good news for realtors. There could be a lot more properties for you to sell if you wanted to list their ADU as a condo. Some people are shaking your head. Some of you don't like this. Remember, I have no opinion on any of this. Don't shoot the messenger. I'm just saying this is a trend going on here. California has basically figured out we need more housing, and ADUs are pretty much the way to go, is what they're saying to you. They make it easier for you to build, easier for you to rent, and now you might be able to actually sell them separately. What a concept. So, in other words, your single family lot would be turning into a very small common interest development. So this would have to comply with the Davis-Sterling law too. But I'm sure all these hoops could be handled. Well, we have no idea what's going to happen. Are any cities going to do this? Yes, sir.
Be able to do that as well.
Yeah, the question is, what about local rules on, local housing rules?
Well, no, I just said basically in regards to the county or city, they would have to go before the commission to be able to get a conditional use permit or a variance on that.
I think it's going to be pretty straightforward that the local government could pass a law that basically would enable them to go around that. We'll see how this plays out. We will see how this plays out. Even if it gets passed, I mean, laws like this sometimes get challenged in court, right? So who knows if this is going to play out. Just like SB9, everyone was all excited about SB9 and it never happened. Everyone thought that everyone's going to turn their house into a duplex or a fourplex. No one's doing that. It's became too hard. Maybe this will also have obstacles. Maybe the cities won't want to do it. I just want to throw it out there. I think it's pretty significant. It's a possible thing that might happen. Okay. So that to me is almost, if it happens, could be pretty significant. All right. I might as well get to the bad news. The bad news is for landlords. Have you noticed in California, it's becoming harder and harder to be a landlord in California? Anytime there's a new law, it's going to be not pro-landlord, it's going to be pro-tenant. That's just the way it is. So, but you need to know. I mean, a general point I make is a lot of realtors do property management, and it's a lot harder than it used to be. I mean, the laws have changed to be more simple. It's only going to be more complicated. So if I have any general tip for you today is if you manage property, know what you're doing, or have the legal hotline on speed dial, because there are two things that come up often for a property manager or landlord: raising rent and evicting. And those are the things that have changed dramatically. I mean, the rules are completely different than they were 3 or 4 years ago on both of those issues. So that's the general point. Now let me get into some specifics. One new thing is relating to security deposit. As you know, today, when you on a residential property, you can take as security 2 months rent, up to 2 months rent if unfurnished, 3 months if it's furnished. People always ask me, can I also get a pet deposit? Well, yeah, you can get a pet deposit, but it can't go over that limit. In other words, you can charge some of your tenants 1 month's rent, and the ones with pets, you can charge them 2 months rent. So you can differentiate between tenants based on whether they have pets, but you still can't go over the maximum. And by the way, of course, you cannot charge a tenant extra security if they have a emotional support animal or a service dog, because you have to allow those and you can't charge extra for them. Of course, if they damage the property, you can hold them accountable, but you can't charge extra rent or security. Whereas with a pet, you could say no pets, or you can allow pets and charge them extra rent, or allow pets and also charge them extra security. The point is, next July, the maximum security deposit in California on residential properties is going to be limited to 1 month. Furnished or unfurnished, pet or no pet, 1 month. Now, the good news is there's an exception for small landlords. I don't mean short landlords. I mean small landlords who have no more than 2 rental properties and no more than 4 units. So if you have 1 or 2 single-family homes, or maybe a single-family home and a duplex, or a single-family home and a triplex, or 1 fourplex, or 2 duplexes, if it's no more than 2 properties, no more than 4 units, you can still charge 2 months, not 3 for furnished. So up until next July, do whatever you want. You can take new tenants and charge them the 2 or 3, and you don't have to give it back next July. And if you're existing tenants who you've got 2 or 3 months, you don't have to do anything. But new tenants, next July, you're going to be limited to either 1 month or 2 months, depending on if you're a big tenant or a small tenant, and it doesn't matter at all if it's furnished or unfurnished. One more caveat is if the tenant is a member of the armed services, it's 1 month, even if you're a small landlord. So I'm not expecting you to memorize all this stuff. It's on a handout. It's with a Newsline last night. You can check it out. So that's one change. Yes. Active, not retired, not at reserve. Yeah, not veterans, right. And by the way, so that's okay. That's July 1st. You can do whatever you want until July 1st. The law changes for new tenancies starting July 1st. All right. Another law affecting tenants, which is definitely the most significant new law affecting tenants, deals with what we call the Tenant Protection Act. As you probably know, cities like Los Angeles, where I'm from, Santa Monica, Berkeley, San Francisco, Oakland, have rent control. Bakersfield doesn't have rent control, right? Okay. But we have state rent control. It happened right before the pandemic. So during the pandemic, we had all these special pandemic rules. pandemic rules are over. People sometimes forget that we still have this Tenant Protection Act, which is not going away. What does that law says? That law says if your rental is in a building that has 2 or more units and it's more than 15 years old, then you're under this special law. Single family homes are exempt. Owner occupied duplexes. So if the owner lives in one of them and he's renting out the other one, he or she is renting out the other one, they're exempt. But a non-owner occupied duplex and 3 or more units got a certificate of occupancy more than 15 years ago, you're restricted by the Tenant Protection Act. And by the way, when I say 15 years, that means you could have a property today that's 14 years and 11 months old. You can do whatever you want. A month from now, all of a sudden you're under this law. So what does this law do? It restricts how much you can increase the rent, and it restricts the reasons you can evict somebody. Okay, so let's start with increasing rent. Every year they give you a new number. It says on August 1st. So, and it's county. So from August 1st to the next August 1st, in a particular county, you can only increase the rent by a certain amount if your property falls under the Tenant Protection Act. Does anyone know what the number is for Kern County is right now? You're right, cost 5% plus cost of living, but what is cost of living? Anyway, 9.2 is the total. For this county, it was designated as 4.2. You probably thought inflation was more than that, but the point is they thought it was 4.2. So if you got a tenant under the Tenant Protection Act in this county and you want to increase the rent, don't increase it by more than 9.2% before next August. Next August, we'll get a new number, but it's never more than 10. It's capped at 10. It's going to be 5. It's going to be between 5 and 10 every year. So right now it's 9.2 for this year. So that's point number 1. Point number 2 is if you have a tenant on one of these properties and you want to evict them, you need just cause. Now, if you have a single family home tenant, you don't need a reason to evict. Assuming they're on a month-to-month, they're not on a lease anymore, you could just say to your tenant, you need to leave. They're going to say, I've been here 20 years, I pay my rent on time, why are you kicking me out? And you say, because you're boring to me. That's what I need a more interesting tenant. I need a change of, the point is you don't need a reason. Having said that, you can still get in trouble though for evicting them for a bad, the fact that you don't need a reason doesn't mean you can evict them for a bad reason. I'll give an example. You have a condo you're renting out, whatever, married couple. All of a sudden they have a kid. A month later you evict them. And then you rent to someone else who doesn't have a kid. What does that look like? It looks like you didn't want a tenant with a kid. So, and you cannot discriminate against tenants based on their family status. So even though it's a single family home and you don't really need a reason to evict, sometimes the circumstances can make it look like you did evict for a reason. I know, how can anyone read your mind? That's not why I evicted them. In reality, you better have a different reason to evict. So even when I say single family home landlords and landlords on newer buildings don't need a reason, that's true. You might want to think about having a reason just in case anyone accuses you of evicting for a bad reason. Okay. And of course, you can raise the rent as much as you want on one of these properties as well. So anyway, what are the legit reasons to evict someone under the Tenant Protection Act? Well, first of all, if they do something wrong, if they don't pay the rent, nuisance, bad thing, if they do bad things, of course you can evict them for cause. But what if there's no cause? They're not doing anything wrong. Under what circumstances can you evict a tenant under the Tenant Protection Act? Only 3 reasons. Number 1, you're going out of the rental business. I'm sorry, I'm no longer going to rent this property. It could be I'm going to sell it, right? Selling it. So I'm going to kick you out. Yeah, but they don't look at it that way. So if you use the excuse, I'm evicting you because I'm going out of the rental business. Obviously, I'm going out of the rental business because I'm going to sell the property. But that means if you're going out of the rental business, the person you sell to also can't be in the rental business. So the buyer can't rent it out either. For how long? Like 2 years. So there's better reasons to evict someone. So the 2 other legitimate reasons to evict someone for for no cause is owner move-in and substantial remodel. Up until recently, we didn't know what that actually meant because they didn't define clearly what does owner move-in mean and what does substantial remodel mean. Now we know, new law tells us. Owner move-in means, listen carefully, it means, so if I'm going to evict a tenant on one of these newer buildings, it's, it's a fourplex and I want to kick a tenant out or something, I'd have to, in my eviction notice, say to the tenant, okay, the reason you're being evicted is because my son is moving in or my mom is moving. It's got to be parent, child, grandparent, grandchild, or the owner themselves, or interesting, their spouse and domestic partner. This is sort of an easy way to split up with your spouse. It's like, nothing personal, honey, but you need to move into the rental. It's, we got to get rid of this tenant. Nothing between us. Yeah, I wish I could still live with you, but I'm sorry, you need to move in. Anyway, the point is, you've got to tell them it can't be a sibling or a cousin or an in-law. It's got to be parent, child, grandparent, grandchild, or the person themselves. It's got to say that on the notice. The person we're talking about has to move in within 90 days and has to stay for at least a year. And the tenant has the right for proof that this person really is related to you, like you said they were. So in other words, the old law didn't really say how long they had to stay there. They could have moved in for a week, then you could move out and then get a new tenant and double the rent or do whatever you want. Okay, so now we know what owner move-in means. We also now know what substantial remodel means. In other words, you say to the tenant, I'm sorry I'm evicting you. Why? Because I'm remodeling the property. Then you paint the kitchen and that's a remodel. I'm going to rent. No, you can't do it. They define now a remodel as the remodel is so significant that the property is literally uninhabitable for at least 30 consecutive days. That's a big thing. Think about that. Think about working on your property. Is it so big that it's just legally and not, the entire property is legally not habitable? That's a substantial remodel. Okay, so now we at least have a little bit better idea what that means. But here's the worst part for landlords of this new law is we have penalties for the first time. Up until now, if you violated the Tenant Protection Act, what was the remedy of the tenant? Probably they could force you to let them back in. But that was about it. New law says if landlord violates Tenant Protection Act either by raising the rent by more than the amount or evicting under an owner move in and then they don't move in or they don't stay for a year, or evicting based on a substantial remodel and the remodel turns out it really wasn't that significant. If any of those things happen, number one, the tenant can move back in. Number two, you have to reimburse them for their moving expenses and any related expenses other than maybe you had to pay them a relocation fee anyway, but over and above that. But third, the worst part is attorney fees. They can charge you attorney fees. And if it can be proven or argued that the landlord knowingly they knew they were doing the wrong thing, but they did it anyway, punitive damages. 3 times the actual damages. I mean, the worst case scenario you can imagine would be, believe it or not, it would work like this. You raise the rent too high or you do a owner move in, but you don't really do it. The tenant figures this out. They could demand that you let them back in. But the tenant could also say, I don't want to, I've already moved. I don't want to go back in, but I'm going to punish you for doing this. And here's how they're going to figure out the damages. I was going to live there for about 10 years. So now I'm paying $300 more at a different place than I would be paying if you'd left me stay there. So you owe me 300 times 12 times 10 times 3 treble damages, plus attorney fees. What is the moral of the story? Please don't violate the Tenant Protection Act. If you have a rental property that fits into this category, be very careful before you raise someone's rent or evict them. Make sure you get advice. Make sure you give them the right format. Follow everything to the letter. It's not easy to be a landlord in California. Just be glad, though, you're not a landlord in, for example, Los Angeles. Do you know in Los Angeles, under local law, everything I just said applies to single family. So imagine you have a realtor, you're in LA and you want to sell a house. You got a house for sale. And the seller obviously wants to kick out the tenant, fix it up for sale. Not in LA, you don't. You got to wait till you sell it. And then the owner can evict the tenant. Or substantial amount, you know what I'm saying? So how do they get around in LA? A lot of times you just bribe the tenant. What do we call this? We call this cash for keys, but you can do it. I'm sure you probably read about that nightmare tenant in LA that's been there on an Airbnb for a year and a half without paying anything. The moral of that story was don't rent an Airbnb unless it's permitted. Okay? Get it permitted first, because otherwise, in certain cities like LA, if it's not permitted, you can't kick them out. But the tenant won't even let the landlord in to fix it up. It's crazy. Anyway, have I discouraged you yet from being a landlord or a property manager? Okay, I'm not done. There's more. Not much more. Another thing worth mentioning is those are the big two. Here's a third one, though. That's pretty significant. You probably know, I've told you, if you've listened to me, that as of recently, you cannot discriminate against someone in a rental situation based on their source of income, if it's a legal source of income. Meaning, and that really gets down to Section 8 tenants. The tenant shows up and says, I'd like to rent your place, and my source of income is, part of my source of income is a subsidy I'm getting. Could be Section 8, could be a veteran subsidy, whatever. And the landlord used to be able to say, I'm sorry, I just choose not to participate in the Section 8 program. And you have the right not to do that. No longer do you have the right to do that, not to do that. Every landlord in California is a potential Section 8 tenant. Landlord, it doesn't mean you have to take every Section 8 tenant applicant who walks through the door. It just means you can't automatically reject them just because of that. I guess another way to look at that is if the most qualified applicant you have happens to be Section 8, you better take them. Otherwise, they're going to say, well, why'd you take someone else who had a lower, a criminal record and lower credit score, whatever, but you took them anyway. It makes it look like the only reason you rejected me is because I was Section 8. So that's point number one. Here's the new law. New law says if a Section 8 tenant comes along. So in other words, if you think about that logically, that means today you could have two applicants, one Section 8, one isn't, and you credit check, right? And the Section 8 one might have a bad credit score. That might be part of their situation. And you could then take the other one based on simply a higher credit score. That's an objective fact. New law says for a rental applicant is Section 8 or gets any type of subsidy, the landlord cannot use their credit history as a reason not to, if they want to, if the applicant wants to use a different criteria called ability to pay. In other words, they're going to, the applicant could say to the landlord, no, I don't want you to look at my credit history. I'm going to give you my bank account, my job history, and you have to evaluate these things reasonably and take it into consideration that in other words, you have to figure out whether I have the ability to pay, not based on my credit history. This is all very vague, of course. Once again, how do you prove what's in the landlord's mind when they pick tenant 1 over tenant 2? We'll see how it plays out. Like some laws, who knows, there may be challenges to this. We don't know, but it says what it says, and it takes effect January 1st. It says landlord can still request documentation of employment. You can still look at landlord references from previous landlords. Of course, you can still check criminal record and stuff like that. There are objective criteria you can use to choose one tenant over another. But I guess what they're really saying is don't reject a Section 8 tenant just because they have bad credit. So based on a credit score or a credit report. So in other words, they have the option of saying, I don't want you to look at you can still look at it, but they're saying, the option, that's not what you judge. I don't want you to judge me on that. You need to judge me on my general ability to pay the rent based on these other factors. No one knows how this is going to play out. So that's the latest. Yeah, I can tell you it's going to play out too. So be careful. Any event, other things you should know about landlords, interesting. You ever run across a landlord who says, you can't store your bicycle in the unit? No more can they do that if they were ever doing it before. In other words, you have to allow a tenant to store bicycles, skateboards, or scooters inside their unit if they want to. Or you can provide them with a storage space outside the unit to store it. It does so that, what about an e-scooter, an electronic bicycle? You know, you have to allow those in, but you can tell them they can't work on the bike in the unit. Okay, at least you can do that. So there you go. Here's another interesting one. Oh, by the way, I forgot to mention something. When I said owner move in, there's another restriction. The restriction is, let's say you got a fourplex. You're renting out all the units and you want to evict one of the tenants because the owner's going to move into one of those units. This only works if the person who's going to move in doesn't already live there. In other words, if your son already lives in unit A and you want to get rid of the tenant in unit D, so your strategy is your son is going to move from unit A to unit D, no. The owner move-in person can't already live there. And this also doesn't work if there's other vacancies in the property. So if you got a fourplex that already has another vacancy, you can't kick out unit D to move your kid into the vacant one. So it's got to be filled up and the person moving in can't already live there. Okay. Sorry, I forgot to mention that. All right. Couple more on rentals. Another interesting one is, and that's not worth mentioning because it only applies to cities with rent control. We don't care if your city doesn't have rent control. So I don't want to give you things you really don't need to know. That's pretty much it for rentals. There's another interesting one, but I don't know how relevant this is going to be. Listen to this one. Starting in 2025, if you have an apartment building of over 16 units and you provide parking to the tenant, so part of the deal, there's a parking garage or a lot. In other words, in this 16-unit building, there are parking is provided. Landlords are going to have to separate the cost of renting the property from the cost of the parking. It's like two separate rental agreements. So if the tenant doesn't pay the parking part, you can kick them, you can deny their parking access, but you can't kick them out of the entire property based on the fact that they don't pay their parking fee. So only new buildings, not existing buildings, only starting in 2025. And guess what? Only in certain counties as a trial project. And guess what? Kern County isn't one of them. So great. So the only time this would affect you is if the trial goes well and they expand it to the entire state, which could certainly happen. In the meantime, when you read about that law in the handout, you'll realize I don't have to worry about that one. All right. By the way, the one I wasn't going to tell you about, I might as well tell you about, is basically you're in a rent control property and someone has a disability, or it's hard for them to get up. They're on the second floor. There's no elevator. They're having a problem walking up the stairs. They have some mobility issues, and a new unit comes available on the ground floor. The landlord has to allow them to move to the ground floor unit without increasing their rent. So even though they're moving for mobility issues, and they're still under the rent control. Normally, obviously, when you move, you go to a new place, they can raise the rent because you're a new tenant. But this would be a sort of an exception to that. All right. That is enough on, yes, sir. No, good question. It applies to same unit size or smaller, but that's only in a rent control situation. So, and you're not in a rent control situation. They could amend the Tenant Protection Act to do that, but they haven't done that yet. But I just want to throw that out there. All right, we're almost done with the new laws. We've covered the disclosure. We covered the ADUs, selling them separately. A couple other things you might find interesting. Have you heard about? Yes.
You keep mentioning a handout.
Yeah.
Where can they get that handout?
Okay, every realtor gets every week or so, you get an email. You get a bunch of emails from CAR. One of them is called Newsline. You got it last night. It came out last night. If you're a realtor, and by the way, if you don't get it, this kind of stuff, you gotta make sure through this association they have your mailing, you have your email address. Because we have a lot of realtors, we don't have their proper email address and you don't get our stuff. But if you have, remember through the local association, if you're not getting a weekly newsletter from CAR email called Newsline, you might want to, through the local association, make sure CAR has the right number. Anyway, Newsline, it's like 4 different things. One of them says new laws. You click on it and you'll see it there. So that's where you get the handout. Yeah. 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 I mean, if part of the deal is they pay utilities and they don't pay it, yeah, that's grounds to evict. Absolutely. Right. Yes. All right. A couple more laws. Have you heard about this company? A couple of companies. There's one in particular throughout the country. This is their business practice. They call up unsuspecting innocent people on the phone, typically elderly, typically English, not first language. And they say, we got a deal for you. We're going to give you $2,000 cash. All you have to do is sign this listing contract. You don't have to sell your house. You just have to sign this contract saying if you do sell, you're going to use us. And it's an exclusive listing for 40 years. In other words, if you sell this house anytime in the next and it's binding on your heirs, by the way, if you sell in the next 40 years, you got to list with us. And if you don't do it, the penalty is like 8% of the value of the property at that time. And they record this listing as a lien against the property. So these have been challenged in court. In California, there's pending court cases. But the good news is, I do have more good news for you, is this legislature has stepped in and said, forget these court cases. It is now California law retroactive that listings in California cannot be any longer than 2 years. They cannot have automatic renewals. Any renewal can be no more than 1 year, and they cannot be recorded as a lien against the property. So the legislature has at least solved that little problem. Let's see, is there anything else you should know? New law effective January 1st says, oh, by the way, those changes, I'm sorry, I keep forgetting. I'm so sorry. That bad thing I was telling you about the Tenant Protection Act, all those special protections that tenants have. I forgot to mention a very important thing. Tenants only get the protection of the Tenant Protection Act when they've been on their property at least 12 months. So, even though you've got an older property, if the tenant in question hasn't been there 12 months, you don't need just cause to evict them. You can just evict them. The problem is, of course, typically when you get a tenant, you get them to sign a 1-year lease. And during that year, you can't do anything because they're on a lease. Then the lease is over, boom, they've been there 12 months. Think about 10-month lease, 6-month lease, 9-month lease, no lease. The advantage of this would be, let's say you had a 10-month lease. 10 months into that lease, the tenants, they're done. You can now ask yourself, how have these 10 months been? Do I like this tenant? Because if I let them stay 2 more months, they're my tenant for life. But if I don't think I want them to be my tenant for life, I can just evict them, no just cause required. So the just cause protections are only for tenants who've been on the property for 12 months. Another thing I forgot to mention is I keep saying single family homes are exempt. True, but only if the landlord has given the tenant a form called the RCJC, Rent Cap Just Cause Addendum. And if you use the CAR lease form, it's pre-attached. You're already doing it. But maybe you've had a single family rental for 5 or 10 years. Never hurts. It's never too late to give them this form. You certainly got to give them this form before you try to evict them. Because until they get that form, they are protected. And you do need just cause. So obviously, at least 2 months before you want to actually evict them, you got to give them a notice of change in terms of tenancy and attach this RCJC form, the rent cap just cause addendum. Okay, yeah. So the next question is, I said these protections of just cause only apply to tenants who've been there more than 12 months. He asks a great follow-up question. Does that mean tenants who've been there less than 12 months, I can also increase their rent as much as I want? No. You're still limited during that 12-month period to this year 9.2%. You can increase the rent 3 times all year, but the total during the 12-month period can't be more than 9.2%. All right. I believe that is it as far as new laws that you really need to know about. There are a couple of other things. Let me see if there's anything else I really think you're really interested in knowing. That's really it. Oh, one more thing. Notaries. Effective January 1st, California notaries will be able to do remote, virtual, online notaries. That is, I mean, today, by the way, you can do in a California transaction, you can have a remote notarization, but you have to use a notary who's licensed in a different state. But if you are using a notary licensed properly in a different state, and in that state, they're allowed to do virtual remote notarizations, you can do it. But the change in the law is California licensed notaries will be able to do this, but not until the Secretary of State issues regulations determining, the process that has to be followed, what technology you can use, what technology you can't use. So this isn't going to happen overnight. Maybe sometime next year, we hope. We'll see. Okay. But anyway, that'll affect some of you. And I think, one more thing. I keep thinking of things. One more thing you should mention. Small claims limits are going up from 1,000 to 1,250. Okay. That's if you do no more than 2 in a year. So if you're doing your 3rd small claims court lawsuit in a year, you're limited to half of that, right? 6,250. But it's going to be starting next year, 12,500 max instead of 10,000 today, 12,500 maximum you can sue for in small claims court starting next year. And this, of course, affects the CAR contract, right? Because when you sign the arbitration clause, you are agreeing that you will not, that if you have a claim against the other side, you can't sue them. You have to take them to arbitration if it's higher than the small claims court limit. So if your claim against the other side is under, starting next year, 1,250, even though you initial the arbitration clause, you don't have to mediate or arbitrate. If it's more than 1,250, you have to mediate and arbitrate if you initial the arbitration clause. So that's a slight change that's going to affect you. All right. Enough on new laws. What else do we have to talk about? We have a lot of other things to talk about. You might as well, you want to talk about buyer brokerage, probably. Everyone else does. Maybe you don't care. The lawsuit has begun. We are in day 2 of a lawsuit in Missouri, one of the 2 big lawsuits, class action lawsuits that are happening in this country that are challenging the commission structure. For as long as there's been real estate in this, at least the last 100 years, here's the way commissions have always worked. Sellers sign a listing contract with the listing agent for X amount. Typically, not always, not required, but typically the listing agent puts that listing in the MLS, offering other members of the MLS to share that money. My seller's offering me, going to pay me this. So if you bring in a buyer successfully, I will pay you a part of that. I'll give you some of the money that is providing to me. You share, cooperation. That's the way it's always worked. The plaintiffs in this lawsuit and the Department of Justice are trying to say that that whole system is rotten, that basic system artificially makes commissions higher than they should be. Personally, I think it's a bogus argument. The point is, what is their theory? The theory is that violates the antitrust laws, which interestingly were passed in 1880. So it took the plaintiffs 140 years to figure out that maybe this violates these 140-year-old laws. That doesn't matter. The point is, these are class action. Who are the plaintiffs? Every seller who sold a house between between 2015 and 2021 in certain states. There's a Midwest one and there's an East one. There's no California sellers as plaintiffs in this case. Okay, so who is being sued? NAR, RE/MAX, Keller Williams, Berkshire Hathaway, and Anywhere. Anywhere means Coldwell Banker, Century 21, Sotheby's, Better Homes and Garden, ERA, a couple others. Anywhere and RE/MAX have already settled this case. So anyway, so what's going on? So the plaintiffs are saying, we paid too much commission. We want a refund of our commission on all these deals. So it doesn't affect any of you, right? I mean, if you work for one of those franchises, it still doesn't affect you. But it does affect people, these big companies, the corporate owned offices, and it does also affect the franchises in these other states. And they're asking for money, return of commission money, but they're also want the rules changed. Okay. That's why they're really suing NAR, because NAR sets the rules and they say those rules are bad. So RE/MAX and any point is, but the case is over for them. And RE/MAX and Anywhere also agreed certain things. We will no longer say, as a buyer's agents, we will no longer say our commissions we're free. But there are rules already say that. We will no longer search for properties, set up an algorithm that searches for properties on the MLS based on how much money we're getting. That's already a violation. We are not going to require our agents to put listings in the MLS. Okay, they're not saying you can't, they're saying you don't have to. People put properties in the MLS because they think that's the best way to sell them, right? It's not like they do it because you have to. Anyway, the point is RE/MAX and Anywhere agreed to do things, but they didn't agree to the big fundamental things, which is mandatory buyer broker contracts. And they didn't agree to that they will not offer properties in the MLS. So the plaintiffs obviously agreed to the settlement, but without any restrictions, showing that what they really want is the money. They don't really care if the rules change, they just want their money. But the NAR part of it is they're trying to get NAR to change the rules, right? And the Department of Justice is along with that. So they want NAR to actually, it's not 100% clear exactly what they want, but I think they want buyer broker contracts to be mandatory, that you cannot work for a buyer without a buyer broker contract. And maybe they want to go so far as to say, you cannot offer commissions through the MLS. They actually may want to try to go that far and say, the only option you have to get paid in real estate as a buyer's agent is through a buyer broker contract. I mean, even if the listing agent wants to offer you money through the MLS, they cannot do it. Which is, by the way, RE/MAX and Anywhere did not agree to that at all. And the plaintiffs were okay with the settlement anyway. So, but we'll see what happens. NAR says, we're not settling, we're going to fight this. And they're in day 2 of the trial. We should have a result in 3 weeks. Stay tuned. This will be big news. There are various possibilities. NAR wins. Nothing changes. NAR loses. But we don't know what that means yet. Is it going to be, if they lose, is it going to be so extreme that buyer broker contracts become mandatory? Or even if it's a possibility they could become mandatory, but you could still offer the money through the MLS if you wanted to, in which case, okay, big deal. I got a buyer broker contract. I'm still going to probably get paid through the listing agent anyway. In other words, even if NAR loses, we don't exactly know yet what that even means. And you know what else? Whoever loses, there'll be an appeal. This will drag on for years. Hopefully I'll be retired. Anyway, but the point is, but there's another possibility. The other possibility is the judge, let's say NAR loses. And the jury says, oh, you got to change the rules. And NAR immediately says, we're appealing. Theoretically, the judge, as a temporary order, could say, NAR has to change certain rules. I do not have a crystal ball on this at all. We're going to know a lot more in 3 weeks. As of now, even if you work for RE/MAX or anywhere, there's nothing you really have to do differently than you did before. Buyer broker contracts are not required, and it is perfectly legal to offer compensation through the MLS to a cooperating agent. That may never change, or it may be tweaked. I could imagine buyer broker contracts being mandatory, but the MLS still being able to offer compensation. Another thing is they're trying to push for is that buyer's agents should have to tell their buyer up front I know you don't normally sit to the buyer and say, by the way, if you buy that house, they're paying me 2.5. If you buy that house, they're paying me 3. If you buy that house, they're paying me 2. None of you do that, do you? It's a possibility that could be required. Even if a buyer broker contract is not required, that might be required. So the various possible things that could happen. By the way, CAR Forms Committee is ready for anything. We've already got a form called the ABCD, Anticipated Broker Compensation Disclosure, which does exactly what I just said. In other words, it is today you could do that if you wanted to. And by the way, buyers can already figure that out anyway, right? I mean, it's now part of the public part of the MLS offer that they can go to the trouble of looking at it and seeing, oh, on this house that I'm interested in, the listing agent is offering this. On this house, they're offering that. So they can, you don't have to bring it up, but they can figure it out. If they're diligent, if they care enough, they could actually do that. And some people do, as someone just said. Buyer broker contract. By the way, forgetting any of this stuff, I think buyer broker contracts are a good thing. Because, I mean, you still have the MLS. Chances are, even if the buyer agrees to pay you X, remember the buyer broker contract says, yeah, buyer agrees to pay you whatever, 2.5%, let's say. But any money you get through the listing agent through the MLS is a credit against that anyway. So I bet most of you don't even use buyer broker contracts. And I bet those of you that do, very, very rarely does the buyer actually have to pay you. Because typically, even when you have a buyer broker contract, you end up writing an offer on a listing in the MLS anyway, where the listing agent is offering money. Typically, at least as much money as the buyer is agreeing to pay you in the buyer broker contract, in which case the buyer pays nothing. Well, here's a thought. Have you noticed there's one more thing on the purchase contract? There's already a paragraph 3G3. Have you ever noticed this new paragraph this year that says, if you check the box there, seller agrees to pay the obligation of buyer to compensate buyer's broker under a separate agreement. If you don't have a buyer broker contract, you're never going to check that box. And even if you do have a buyer broker contract, you don't have to check that box. But the way that would work would be is, let's say you have a buyer broker contract, your buyer has agreed to pay you, let's say 2.5%. If the buyer broker contract says, if I help you buy a house in the next 60 days, you agree I get paid 2.5%. Then you write an offer on an MLS listing. The listing agent happens to be offering 2% on this listing. That means the listing agent's only going to pay you 2, but your buyer has agreed to pay you 2.5. That means your buyer owes you 0.5%. So you can say to your buyer, you owe me 0.5%. But then the buyer can say, I don't have to pay you anything. I never thought I was going to actually have to pay you. This is crazy. You can check the box in paragraph 3G3, basically saying to the seller, you're basically saying to the seller, hey, your agent was so cheap, they didn't offer enough money in the MLS. So it turns out I actually owe my agent some money. I want you to pay the agent I owe the buyer is saying to the seller, I want you to pay my agent the money you owe them. I owe them. And that's perfectly legal. You can ask the seller to pay for anything, right? You can ask the seller to pay for closing costs, termite report, NHG report. You could ask the seller to buy you a car as part of escrow. You know, they don't have to do it, but anyway. So here's my ultimate prediction. Imagine if worst case scenario happens and it's illegal to offer the buyer's agent money through the MLS. And the only way you can get paid is if the buyer agrees to pay you under a buyer broker contract. And if that happens, imagine this, when you go to a listing appointment, you're not going to be able to get a seller to agree to pay you 5 or 6% because they're going to know you don't have to share it with the buyer's agent. So they'll probably list it with you for, 2 or 3%. Then the buyer's agent realizes to get paid, I got to get my buyer to sign a buyer broker contract. So you're going to say to the buyer, okay, you need to sign this, pay me 3%, let's say. Buyer says, I can't afford that. Well, then let's just check the box in 3G3. Let's have the seller pay the 3% that you owe me. And my philosophy is sellers are used to paying 5 or 6. They've just signed a listing to pay 2 or 3. They'll probably be willing to continue to pay. Who knows? I mean, you know what I'm saying? It may be back to just the way it is now. If this even happens, and nothing has happened, and nothing may never happen, there's probably going to be an appeal, which will drag this on for years. We'll all be retired before this gets resolved. So there's nothing you can do. The only thing I would say now, other than follow this, is buyer broker contracts are still a good idea. You know why they're a good idea? Because for a couple of reasons. One of them is, let's say you do have a buyer broker contract and your buyer does the old stab you in the back. You find the property, instead of writing it up with you, they write it up with their brother-in-law who just got his license. I mean, you got procuring costs. You can take them to arbitration, pay a fee. You might win, you might not win. But if you have a buyer broker contract, you can just sue your client and say, normally you don't have to pay me, but since you screwed me here, you need to pay me because I helped you under the terms of the deal. You didn't use me. You owe me money. In other words, you wouldn't have to take the other agent to arbitration. You could just simply sue your own client for doing that. But you could still go to procuring cause arbitration. Plus, the reason you could even have a buyer broker contract where you'll agree to pay, the buyer agrees to pay you $50. What's the advantage of that? Well, at least you have a relationship. You've defined the terms of your legal relationship. I think buyer broker contracts are a good thing. The other thing to think about, and then I'll be done talking about this unless you have questions, is as a listing agent, you are used to having a conversation with a potential client, convincing them that you're worth it. A listing presentation, you marshal evidence and you convince them how good you are. You have a plan and you convince them that you are worth the money you are asking them to pay you. But you don't typically do this with a buyer. I mean, it's sort of like you're a travel agent, right? I mean, the buyer sort of vaguely knows you're getting paid, but at least I'm not paying you. Which they are paying you indirectly, of course. All commissions come out of the purchase price anyway. But the point is, maybe you should start thinking about at least, or practicing, how would I have this conversation with a buyer to convince them why I'm worth what I'm asking them to pay me, or even why I'm worth what the listing agent is going to pay me for representing them. I mean, you are worth it, obviously. And there are all sorts of materials out there that you can access to help you do this. Maybe it's something to start practicing or not, or whatever. The point is, there's a possibility where this may become a real requirement, where you're actually going to have to sit down with your buyers and say, I need you to sign this document where you're agreeing to pay me some money. And this is why you should do this. This is why I'm worth it. Okay, so something to think about. All right, enough on that. We are done with, that's a big issue, but we finally are in the trial. We'll see what happens. Stay tuned. Nothing has changed yet. Nothing may change ever. Nothing may change for a while. Stay tuned. All right. The only other thing to talk about is forms, right? We've talked about the new laws. We've talked about buyer brokerage. Forms, we should know about what's changing, if anything, on the forms. I've already told you changes that when I was talking about the laws, how the TDS is going to have a new box reminding flippers that you have a new disclosure obligation. There's going to be a new question on the seller property questionnaire dealing with that. So you got that. All of these changes I mentioned on rentals are going to be incorporated into our lease forms and our notice forms. You know, the notice of termination of tenancy is going to explain everything I just told you. By the way, on the cash for keys form, that's when you have a tenant, you want them to leave, they're giving you a hard time. You say, oh goodness, I'm going to have to evict them, hire a lawyer. Maybe if I just bribe them, they'll leave. So you offer them cash for the keys. Perfectly legal. We got a form for this, cash for keys. There's a recent lawsuit a few months ago that said the only way this is legal is if it's the tenant's idea. It's never the tenant's idea. But the way to handle this is, as long as the tenant signs the cash for keys form before the landlord signs. So our cash for keys form, if you go to it today, it has a cover sheet. The cover sheet you don't give to the tenant. The cover sheet tells you, the landlord, you can fill out the form, but then send it to the tenant unsigned. The tenant has to sign it. In other words, you would come up with the offer. I'm offering you X amount of money if you give me the keys. Fill it out, but don't sign it. Send it to the tenant. If they like it, they'll sign it, send it back, you sign it, then we have a deal. Okay? The only way you know this is because it's on a cover sheet. Here's another one that probably no one in this room actually knows, but believe it or not. Remember during the pandemic, remember the Federal CARES Act, that big law? Remember that for a while there was big federal regulations of rentals, and that expired. But for some reason, the federal government still hasn't rescinded a particular part of that law, which says, listen carefully, it says if you're evicting a tenant for non-payment of rent, and the property, the rental property that they're living in was purchased with federally related financing, FHA loan, VA loan, or even a conforming loan that was sold to Fannie or Freddie, if that's how the property was acquired, if you want to evict someone for non-payment of rent, you can still give them a 3-day notice to pay, but not 3-day notice to pay or quit. 3-day notice to pay, 30 days to quit. So in other words, even though they don't pay the rent, you give them 3-day notice. If they don't pay in 3 days, they have to leave. You can't start the eviction for 27 more days, which means 27 days of free rent for that tenant who hasn't been paying anyway. No one knows about this law. Fortunately, most tenants don't even know about this law. So all day long, landlords are giving tenants on these properties normal 3-day pay or quits. Tenant or their lawyer doesn't even know about this. Don't tell them. But occasional tenant does know about this, and they refuse to leave, and they tell the judge, and the judge makes the landlord start all over with a new notice, etc. You, if you're a property manager or a landlord, we have a 3-day notice form. It's called the PRQ, pay, rent, or quit. If you go to that form on Zip Form, there's a cover sheet telling you what I just told you. Say, hey, before you do this form, ask yourself, how did I finance the purchase of this property that I am now renting? I know what you're thinking. What if it's paid off? So I bought it with financing, but I own it now free and clear. Still applies. The only place this wouldn't apply is if you bought it with cash or you bought it with a jumbo loan, a non-conforming loan. Nobody knows this though, so you can roll the dice and hope the tenant doesn't figure it out. Just give them a normal 3-day pay or quit. If they don't live in 3 days, start an eviction, do the eviction. If they don't raise this issue before the eviction is completed, you're good. But just one more complicated thing about being a landlord. And that's, by the way, this is a national law. This isn't even just California. Isn't that crazy? All right, let's wrap this up with form changes other than what I've just told you. So the cash for keys form slightly changed. Pay, rent, or quit form slightly changed. all the rental forms and the notice forms are going to be incorporating all these changes. And some people don't want to hear about forms. That's okay. I'm just kidding. And then the TDS and the SBQ are going to change. Other forms that have changed this year or going to change before the end of the year. This won't take long. The only mandatory form that came out this year was the new solar form, SOLAR. If you have a listing and your property is receiving any type of, the property is getting any of the source of its energy from solar, you got to fill out this questionnaire to the best of your ability, the solar form. Okay, SOLAR. Other new forms that came out this year, no big deal. Did you notice the contingency removal form split into a buyer contingency removal and seller? So depending on who's removing the contingency, it's no big deal. Another change is we used to have a pet addendum because landlords don't have to allow pets. But if they do have a pet, they can have rules for the pets. You can only have a pet of a certain size. They can't go outside. I mean, they can't go inside. What you can have restrictions on the pet addendum. This form has been changed now to the animal addendum because some people have service dogs or emotional support animals who are not pets. But, and as a landlord, I think you have to allow them. But you can still have rules. I mean, you don't have to allow any emotion. If they, if you have a 500 square foot condo and they have a 200-pound emotional support dog, you could say that is too big for this unit. You'd have the right to say that. And you could also have the right to say, I don't care if it's an emotional support animal, if it barks too much or bites or menaces people, you have to get a new one. You're allowed to do that. So the point is we have the pet addendum has morphed into the animal terms and conditions addendum. All right. Yeah, terms and conditions. Anyway, another one is, I don't know if it ever is or is currently a practice common here, but do you ever have buyers who make non-contingent offers? Sometimes a property, there are not a lot of properties available, so there's going to be a lot of buyers competing for this particular listing. You want to make your offer stand out, so you remove your contingencies in the offer. That's risky. So people have been doing that, of course, and then things don't go well, and then they blame their realtor. She made me make a non-contingent offer. It wasn't my idea. She made me do it. So we got a new form. Non-contingent offer advisory. The idea being you'd give it to the buyer saying, what you're doing is not my idea. Be careful, understand the risk of making an offer without a contingency that takes away your right to get out of the deal if something goes wrong. I am not advising you to do it. So good form to use, not required at all. Another one, getting back to the rental situation. As you know, as a seller, you have many disclosure obligations. You have to provide the TDS, the SPQ, the lead paint, the natural hazard disclosure, the fire hardening. There are all sorts of forms you need to give to a buyer when you're selling residential 1 to 4. Even if you're selling more than 4 units, there's disclosures. You still got to do the NHD. You still got to do the lead paint. There are other, you can notice on our income purchase contract, there are other disclosures. There are all sorts of disclosures when you sell. What about when you rent residential property? I'm renting my house. I'm renting a duplex, fourplex. Are there any disclosures I have to give to the tenant? There are, but up until recently, they were all incorporated into the lease itself. You got to disclose bed bugs, pest control work, lead paint, death on the property in the last 3 years. Was the house ever a meth lab? I'm sure you sell a lot of meth labs. But anyway, the point is, they were all built into the lease. Here's the change. Most of the mandatory tenant disclosures have been taken off the lease, and they're now on a disclosure form called PO, Property Owner Disclosure. Don't worry, it's attached to the lease. You can't miss it. And it's actually good news for anyone who doesn't use a CAR lease form. You still can use the RPOD and you're still doing all of your mandatory disclosures. I don't know why you'd ever not want to use a CAR lease form, but nevertheless, there's a good form. All right, got that? Another form came out called the RPOQ, Rental Property Owner Questionnaire. This is not a form you give to the tenant. This is a form that the property manager gives to the landlord. You know, maybe you have a lease listing, or maybe you have a landlord or your property manager, and they say, find me a tenant and put the lease together. Well, to put the lease together, you need input from the landlord. Like, you got to ask them, okay, do you have rules on pets, emotional support animals? Do you have rules on parking? Do you have rules on taking care of the vegetation? You need to know what those rules are so you can put them in the lease. Plus, you need to ask your client things like, how many smoke detectors do you have? How many carbon monoxide detectors do you have? How old is this property? In certain counties, you have to make plumbing upgrades depending on how old, you know what I mean? So we have a nice form now where you give it to your client, the owner, and they'll fill it out, tell you all these things, and now you can take that information to help you prepare the lease. I'm sure this has been done informally in the past. There's now a form. So that's all good. Any other new forms that you came out? Not really. What's going to come out in December is, so far, it doesn't look like a lot of new forms at all. I think there's going to be an insurance advisory. By the way, you notice I didn't talk about any new laws on insurance because there aren't any. But the commissioner is in the process of coming out with regulations that would basically say, you know how State Farm left the state and the others left state, we're not writing any more new policies. These regulations would, and the reason they're doing this is because they can't raise the rates as much as they want to in high risk areas. So new regulations are coming, which would make it easier for insurers to raise their rates on the condition that they come back into the state and agree, not only come back in the state, but agree to write policies in high risk areas. So the question is that a good or bad? I mean, which would mean, in other words, you wouldn't be limited to the FAIR plan. Even if you were in a very high fire risk area, you could still get an insurance policy from a private insurer, just you'd have to pay, more money. So anyway, regulations are coming. Stay tuned for that. Other form changes. What's going to be the December form changes? Really not much. They're not really finished yet, but as I said, there's going to be an insurance advisory. I think there may be a couple of new property management related forms, but nothing transactional that I've seen so far. What about the forms you already have? Have there been any changes to those worth mentioning? I mentioned cash for keys. That changed. I mentioned the TDS. Other forms that have changed this year that you should know about. Purchase contract. We should know has anything changed on the purchase contract this year? Well, first of all, there's a new paragraph 11M dealing with solar. I told you there's a new solar form. So on the disclosure paragraph, it reminds you to do that. I already mentioned paragraph 3G3, where buyers ask sellers to pay the commission they owe their own agent. Other changes, just a couple others. Paragraph 7A has been tweaked to deal with the issue of, okay, I'm selling you my house. We all agree on the closing day is November 1st. The closing day is not necessarily the move-in day, right? I mean, change of possession doesn't automatically happen on closing. When does it happen? Well, on the purchase contract, paragraph 3M on the second page, that's where it talks about possession. And what it says is there are two categories: seller occupied property and property occupied by other people, like tenants. And if it's seller occupied property, you probably notice you have three choices. Seller's going to leave close of escrow. They're going to rent back for less than a month. They're going to rent back for more than a month. Three choices. But what if it's not a seller occupied property you're selling? It's occupied by other people, like tenants. Question is, when does the tenant have to leave? If you've ever looked at that paragraph, it doesn't say. It says you need to attach an addendum called the Tenant Occupied Purchase Addendum, TOPA. And that's the form that's going to say, when are the tenants leaving? For some reason, we've noticed that when you represent buyers, you don't always attach that form. Sometimes it's because the buyer doesn't really know who's living there. So it doesn't occur to them to do that. And then there's a problem with a tenant in the property and they haven't been given notice to leave and blah, 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 blah. So point number one is try to use that form. And the purchase contract now says in that paragraph 3M, if the buyer, it says to the seller, hey, seller, if there's anyone living on this property who's not on title, who's an adult. By the way, when sellers leave, they have to take their minor children with them. You can't conveniently leave your 12-year-old behind. No, you got to do that. Okay. But if anyone is an adult living on the property who's not on title, an adult child, brother-in-law, sister, neighbor, friend, tenant, you need to somewhere address when they're leaving. So the purchase contract says, seller, if the buyer doesn't attach a TOPA to their offer, you need to counter with a TOPA that says these are the adults not on title who are living on the property, and this is when they're going to leave. However, so if you don't want to have to go through that process, paragraph 7A now says, in the absence, if you don't for some reason use a TOPA, seller is guaranteeing the property will be vacant at close. So if that's the case, if as a seller you're sure the property is going to be vacant, you're sure everyone's going to be gone on the closing day, you don't have to do the TOPA. Just you're supposed to, but if you don't, at least paragraph 7A addresses the issue of when are people leaving. Having said that, if I were a seller, I would still want to use the TOPA, because here's what the TOPA says. It says, you're saying to the buyer, these are the adults living on the property. I'm going to use my best efforts to get them out by close. But if I can't get them out by close, you have two options as a buyer. Number one, cancel the deal. I give you back your money, go away, or close and deal with it yourself. You do not have the third option of suing me. Cancel or close. Whereas if you don't use the TOPA form, paragraph 7A says the seller is guaranteeing the property will be vacant. Meaning, if it's not vacant, yes, buyer can cancel, or they can close, or they can sue for damages. So if you want to protect yourself from a potential lawsuit for damages, the TOPA form, I think, is a good form for the seller to use. Okay? I'm losing my audience here. I'm almost done. Last thing to mention on the purchase contract change is we finally have a definition of legal holidays. As you probably know, the purchase contract is full of deadlines, 45 days to close, 17 days to remove contingency, 7 days to do this, 5 days, 3 days, whatever. All of those deadlines typically start on the acceptance day, and then they end 3 days, 7, whatever day. But if that last day falls on a Saturday, Sunday, or legal holiday, it's not the deadline. So if I have 17 days to remove contingencies and the 17th day is a Saturday, I don't have to remove them until Monday midnight. If I give you a notice to perform, I give you a 2-day note, you missed your deadline, I'm giving you a notice to perform on Friday. Once again, your deadline would be Monday, because the deadline can't fall on a Saturday or a Sunday. And if Monday's a holiday, you go to the next business day. There are only 2 deadlines in the purchase contract that can possibly occur on a weekend. One is the move-out day. If the move-out day falls on a weekend, that's fine. Also, the buyer's offer. Remember, a buyer's offer is good for 3 days. That can end on a weekend. So if you write an offer on Thursday, your offer is good until Friday, Saturday, Sunday at 5 o'clock, whatever. Every other deadline cannot end on a Saturday, Sunday, or legal holiday. But the question is, what are the legal holidays? Is Cinco de Mayo a legal holiday? Sadly, no. Is Halloween a legal holiday? No. Is St. Patrick's Day a legal holiday? No. All the good ones are not real holidays. But there are real holidays that you never would have occurred to you are real holidays. First day of the Lunar New Year, Indigenous Persons Day, Juneteenth. These are legal holidays that deadlines cannot end on those. How are you going to know, right? How do you know which are which? That's what I'm building up to. The purchase contract in the definitions paragraph now says these are, well, you wish it's going to say a list of the legal holidays. No. It says legal holidays for purposes of this form are the legal holidays listed in California Government Code 6700. You have to Google California Government Code 60. In other words, you're in an escrow, you have a calendar that lists all these holidays. You see that this particular deadline falls on this holiday you never heard of. Is that a real holiday? Feel free to call the legal hotline. We will tell you, or better yet, pick up your phone, Google 6700, see if it falls on the list. All right. Last thing. Did you know that speaking of deadlines, when I have a deadline to give you something, remove a contingency, that means by the end of the deadline, I have to deliver a document. I could deliver a contingency removal or something like that. Okay. Do I have to deliver this physically or can I email it to you? Obviously, you can email it. The problem is when I send you an email, okay, this is my deadline to remove the contingency. I'm sending you an email. Attached to the email is my contingency removal form. And then the other agent says, I never got your email. You said you sent it on time. I didn't get it till the next day, or I never got it at all. Or better yet, I got it, but it's in my inbox. I never actually opened it, which leads to a question. If I send you an email that you don't open it, have you legally received it? Believe it or not, the courts have never resolved that. Which is why, for the last 30 years, ever since email has been common, I've reminded all of you, every time you send an email, follow up. They must acknowledge receipt. Get them to respond either on a text or an email or a phone call. Yes, I got your email, because otherwise the potential was them saying I never got it. This has changed. The purchase contract now says if you send an email to the email address that the other agent gave you on the purchase contract on the last page, you don't have to prove that they got it or opened it. All you have to prove is that you sent it. So your computer shows a record of when you sent it. And if you sent it on time, the fact that they didn't get it, went to their spam, they weren't looking at their email, they didn't open it, none of that matters. You sent it. So that's really good. The problem is if you've looked at the last page of the purchase contract where the agent signed, for this to happen, the agent has to check a box that says, yes, the email that's on the purchase contract, that is the right email to send stuff to. Problem is, what if the agent doesn't check that box? You're back to where you were before. So we have a good form where you can just harass the other agent. It doesn't really necessarily have to involve the buyer. And let's say you write an offer, it gets accepted, you have a deal where you have an escrow, great. But the other agent didn't give me the box. And that means for the rest of this escrow, I'm gonna have to worry about if I send them stuff, they're gonna say they didn't get it. So you can send them a form called the DEDA, Designated Electronic Delivery Addendum, which basically says, please check the box and send it back, or send this form back to me saying you've checked the box, saying you agree that that's the right email address. So I don't have to worry about the rest of this deal harassing you to make sure you got the email. Okay, so there you go. That is pretty much it. By the way, to follow up on what I was talking before about pets and service dogs and emotional support animals, it's not just in the rental situation. The DRE is very big on this now. Open houses and showings. You have an open house. Your client, the seller, says, don't let any dogs and don't let any kids on my open house. I don't want any kids running around. Especially don't want any animals running around the property. You can't do that anymore. If someone shows up at your open house with a little dog. You say, I'm sorry, no dogs. If they say that may look like a dog, but that's not really a dog, that's an emotional support animal, you got to let them in. Now, you can demand that they give you proof at that moment in writing, something signed by a caregiver, not someone on the internet. Someone who's personally providing care to them has written in writing, yes, I'm taking care of this person, and in my opinion, they are disabled and need an emotional support animal. You can insist on that. But if they have that paperwork, you can't turn them away. You got to let them in the property. Unless, of course, it's unreasonable. They have an emotional support gorilla. Okay, you can say, no, that's not reasonable. Or more seriously, the seller's allergic to dogs or something like that. But this, everything I just said also applies to showings. You can't say to your agent, yeah, people can, during a showing, I don't want people to bring their dogs into the house. If it's an emotional support or a service dog, you don't have that right. What about kids? Can't I just say you can't bring your kids in? Yeah, tie them to a tree outside. No, just kidding. The point is, yeah, technically you can say that, but what does that look like? They're going to say, well, they don't want me to bring my kids in. Maybe they don't want to sell to people with kids. Maybe this makes it look like that I shouldn't even bother writing an offer because they don't want to sell to people with kids. They don't like people who with whatever. Who knows? I'm paranoid, but I see the lawsuits. I see the complaints. I mean, you can have reasonable rules. Like you have a kid in, you got to bring someone who's with the kid every second they're in there. Bring two adults because they can't let the kids run free, whatever. But just the DRE is sort of looking at this. They're big. By the way, speaking of the DRE, they're real conscious now about realtors doing property management. And they're also very concerned about realtors who own their own escrow companies. So that's who's getting audited now, realtors with property management companies and realtors with escrow companies. That doesn't mean they're not auditing other people, but that's a focus of the Department of Real Estate right now. All right. Any last questions? I think that's pretty much it. Yes.
Hi.
Hi.
So Section 8 requires the landlord to sign a contract to Section 8. I thought it was unconstitutional to force a citizen to sign a government contract.
Dream on. No, I mean, no, it's not. Yeah, I mean, you can force someone. When I say you're forced to be a Section 8 landlord, that means, let's say your most qualified tenant is a Section 8 tenant. But Section 8 means every community, Bakersfield has a local agency that is responsible for administering Section 8 in this area. So some landlords try to say, well, it's not that I don't want Section 8 tenants. It's just my property, I'm sorry, isn't qualified. I mean, the way my property is set up, it's not qualified under the Section 8 rules. Sorry. The response is, then update your property. Make it Section 8. Well, that's going to take me a couple months. Okay, fine. We'll wait. And by the way, the tenant can actually move in and not pay rent during those 2 months. Yes, it's that severe. So just keep that in the back of your mind. It's all constitutional. I mean, by the way, did you hear that there was a lawsuit that was going all the way to the Supreme Court dealing with the constitutionality of rent control? They didn't take the case. So rent control is still constitutional. That's it. The last thing to try to end on some possible good news is it looks like we might be successful on the federal level from increasing the exemption amounts from capital gains taxes. I mean, normally you don't think about capital gains tax when I sell a house. But if you're married and you sell a house for more than $500,000 more than you paid for it, you're going to owe capital gains tax. If you're single, more than $250,000. I mean, when this law got passed a long time ago, the average sales price in California was like $100,000. Sellers almost never paid capital gains tax. But nowadays, it's more and more common that you bought a house a long time ago, you're selling it today, it may be worth, if you're single, it may be worth $250,000 more than you paid for it. So The good news is there's a federal bill proposed that would double those amounts. So single 500, married 1 million. And one last tip to take you with, you know, the statewide buyer and seller advisory form? How many of you always use that form? I wish you all did, because everything in that form was in response to a lawsuit that a realtor lost. That's why the form keeps growing. Every time a realtor loses a lawsuit, we say, "Oh, we didn't know realtors could get sued for that. We better add a paragraph so it doesn't happen to you." And the latest thing is what I was just talking about, capital gains tax. Someone actually sold their house and then they got capital gains tax. And they said, "My realtor never told me that was a possibility. I'm suing my realtor." Realtor's defense was, "I'm not required to give you tax advice," which I thought was the right answer. The judge said, "Well, yeah, but you should have at least highlighted the issue." Now, if they ended up settling the case after the judgment, I think if they would have appealed, they would have won. I think a court of appeal might have said, "No, that's tax advice, you don't have to do it." But to be safe, the forms committee just added a new paragraph to the statewide buyer and seller, which says, "Hey, buyer and seller, be aware that there's a possibility of capital gains tax consequences when you sell a house." See what I'm saying? Realtor loses lawsuit, we grow the form, but the form you should use because it protects you. Everything in that form is for a reason. It protects you. So that's my sales pitch for the form. Yes. Okay.
Addressing, So in the past,
Yeah.
we didn't use the RPA to negotiate any type of compensation because it was tied to a separate agreement between
Right.
broker and seller.
Right.
Now the box incorporates an agreement between buyer and buyer's agent. Do you see this going down the path where eventually the buyer can, in the counteroffer or in the offer, ask the seller for compensation for their representative?
Well, that's what it does right now.
So we don't have to have a separate buyer broker
No,
agreement.
you do. In other words, point number one, everything you said is right. The code of ethics doesn't allow you to negotiate the cooperating commission you cannot write in your offer, seller listing agent will increase the amount of compensation offered to whatever. You're not allowed to do that, unenforceable, unethical. But as I said before, you can always ask in the purchase contract the seller to pay for something. Now, it does say that you still have to have a separate compensation agreement. You can't just write in the offer, seller to give me money, to give me X amount of money to pay my agent. You have to say, based on my buyer broker contract, I want the seller to pay the money that I owe based on that. So there still has to be either a listing contract or a buyer broker contract or just a single party or a commission agreement. There still has to be a separate document. Just you could reference that document in the purchase contract.
So that's my question.
Yeah.
In your expert opinion,
Yes.
do you see this headed in the direction where the agreement that can be referenced is the listing agreement, not a buyer broker agreement?
Well, how would that work? In other words, the buyer's trying to, why does the buyer care what the listing contract says?
I just think with this lawsuit that's going on and all of this addressing of compensation and
Right.
who can pay compensation, et cetera,
Right.
that at some point, the listing agreement is going to be between the broker and the seller exclusively.
Right.
So any other compensation has to be tied to another contract between
Right.
someone or strictly between the buyer and the seller. If you can ask the seller to pay for anything, why can't you ask the seller to pay for your representative's compensation?
Yeah, but I still think you can if there's a buyer broker contract.
So at this
Yeah.
point, there has to be a separate agreement
Yeah.
that stipulates what compensation
Right.
is and why it's being paid.
Right.
So you're not going to give me your opinion about where you
No, I don't think
this is
I don't
going.
think that's going to happen. No, I don't think
Okay.
I don't think that would happen.
Okay, thank you.
But anything is possible. In this environment, anything is possible. Yes, sir. Are you saying you don't trust me when I tell you what it is?
Oh,
Just
no,
kidding.
I believe you.
I'm just kidding. There is.
There's many places to get CPI.
There's a,
I don't know
there's a
if there's
particular place.
designated
If you email me or call the hotline, yeah, I'm just kidding. There is a definite place you can go to that shows for each county how much the CPI for purposes of the Tenant Protection Act. I think that's what you're referring to, right? Yeah, there is a place. I'm sorry, I don't have it at the top of my head. If you email me, govh@car.org, anybody can email me, govh@car.org, or it's on our website, but I'll send it to you. It's there somewhere. Any more questions? Yes, sir. Yeah.
Does that still apply with a single family and an ADU?
So in other words, you have a single family home and then you have an ADU and you're renting out both. It's no longer a single family home. Well, let's put it this way. There are various, maybe the quick answer is it's no longer a single family home, but one issue that comes up sometimes is people have like a duplex and you can build an ADU on the duplex, on the lot with the duplex. And the duplex was built more than 15 years ago and the ADU is newer. So sometimes on the same property, the properties were built at different times. So some of the units on the property are subject to the Tenant Protection Act and some aren't. But to get back to your simple question, yes, you have a single family home and an ADU and you're renting out. That hasn't been really litigated yet, so I'm giving you my opinion, but it looks like that since you have an ADU on it and then you're renting them both out, you're not exempt as a single family home. I can't guarantee that though. I can't guarantee that because that's still a debatable issue. What is not debatable is cities cannot tell you you cannot rent out the ADU. But cities can, of course, tell you you cannot do a short-term rental. Cities and HOAs can absolutely prohibit short-term rentals of ADUs or anything. They're prohibited. Airbnbs. In other words, they can prohibit Airbnbs. Does Bakersfield have any regulation of Airbnb? Yeah.
So there are 5 dogs that no insurance company will cover. Does a landlord have to allow these breeds as service dogs?
I bet now I figured out what you're doing. These are the Zoom people's questions, right? Okay. I should have. If it's a service dog, you absolutely have to, by the way, you can leave. Those are going to leave. I won't be hurt. If it's an emotional support dog, you could say no pit bulls or something like that. You could probably get away with that. If it's a service dog, if it's a legit service dog, meaning that it's been actually trained to perform a disability related service, you have to accept it no matter what it is. Any more Zoom questions out there? Yes. Yeah.
That's an R1 lot.
Yeah.
Now, what about an R2 lot? If you have an R2
Yeah.
lot, then it's already zoned for 2 units.
Right.
Now, does that mean that an R2 lot can have more than 2 units?
Yes.
And what would that be?
An ADU.
No, but I mean, so 2 units plus one more?
That's a good question. I'd have to look into that. I think it's only one more. In other words, I think a city could restrict you from more than one.
Okay.
The whole point of ADUs is cities don't have the discretion to say you can't build it. I mean, they have to have a reason like it's too big or you can't, no safety reasons or build, but cities used to have the absolute discretion to simply say, no, can't do that. Then you first, yeah.
So for the owner move-in rule,
Yeah.
is there a limit on how many? So you said it could be, parent, child, grandchild, everything. Can you move into more than one unit as a family? Like a family member moves into the second unit as well?
Yeah, it's good to have a lot of kids. You can move into a lot of different units. You got a 10-unit building, you got 9 kids, move them all in. Yeah, but they got to stay for a year.
About an ADU, I know in the past, if you could build a unit, it had to be half the size of the original house. You couldn't have a working stove. Is there now an ADU now, can it be a fully functional unit with a
Yeah.
stove? Okay.
Yeah.
Because you used to have like a hot plate or a
No,
microwave
yeah,
only.
And you get these prefab ones where they just bring them by and plop
Right,
them down on
right,
the
okay.
crane. By the way, here's an idea for you to make money. Can you get into the business of working with a company that makes prefab ADUs and go out and find clients, and they'll pay a referral fee if you refer them business to bring an ADU. Don't get too excited. You can't do that. Unless you have a mobile home dealer's license, a manufactured home dealer's license, then you can get paid for referring those. Okay, something to think about. Which one? Yeah, no, have you noticed there's a little bit of chaos in Congress right now? Well, if anything ever gets resolved and all the spending, but when that happens, yeah, it'd be part of that. But who knows when that'll happen at some point, I'm sure. So whenever that happens, yeah, then we'll know.
Me again.
Someone on Zoom.
A follow-up question to the dog breeds.
Yeah.
They want you to clarify what you meant on the dog breeds. The ADA says no discrimination on breeds.
Okay.
Yeah, it was about it.
Yeah. In other words, that I should have clarified that. So in other words, landlords is trying to say, okay, yeah, obviously you're allowed to have a emotional support animal, but your emotional support animal is a pit bull. And my insurance company absolutely says they will not insure this property if certain breeds are present. One of them is a pit bull. And there was actually a case on this where the judge said to the landlord, well, are you sure there aren't any other insurance companies that service this area that do allow pit bulls? So maybe it's not as simple as that, but that was just one case. So yeah, insurance is the issue, why you can reasonably reject certain breeds. ADA doesn't, like I keep kidding around about the emotional support gorilla, but I mean, yeah, you can be reasonable. You can make reasonable distinctions on type of animal, size of animal, breed of animal, and definitely past behavior of the animal if you're aware of it. By the way, which leads to another interesting question. You're a landlord, you have a tenant, you allow the tenant to have a dog. Dog of your tenant bites the next door neighbor. Can the next door neighbor sue the landlord for allowing their tenant to have a dog who bit them? Well, they can sue. Will they win? Well, guess what? California has something I call the one free bite rule. In other words, in all seriousness, landlord had no reason to know that this dog had a propensity to bite. But now I do know that the dog does have a propensity to bite. So if that dog bites someone else, landlord can get sued. In other words, landlord, what you should do in that circumstance is say to the tenant, you got to get rid of that dog. You got to go where the dog has to go. Yeah, but it's an emotional support dog. I don't care. I am potentially liable for injuries caused by your animal because I'm knowingly allowing you to have an animal run free that has a propensity to bite people. Something to think about, right? One free bite. Remember that, one free bite. Any more Zoom people? The lazy Zoom people are asking questions. They're sitting in their beds there with their cocktails. Okay, everybody, bye. Madam President, thank you.